Hey guys, it's Kathy. I hope you're doing well. I wanted to get this out earlier today, but I couldn't because I am now sitting in air condition. So I was busy today. Oh, yay. So I'm so excited. So this video that nothing crazy happens. It's nothing crazy. No one screams at the judge or anything. It's just an interesting case. I thought it was very interesting. So the full hearing that I took today is an hour long, and I have that on my Patreon. So if you want to see the full thing, it gets a little boring. It parts. I'm not gonna lie, but it's on my Patreon. You can see it for free. You don't have to pay any money or anything, but you can go there. So i- when you start watching it, this isn't what you think it is. Wait till you start watching it, and then you realize it's something completely way different. But what it is the plaintiff in this case is asking for a summary judgment, and I'm only 50% sure it's the plaintiff at this point. So the first lawyer you see is asking for a summary judgment. He wants the case gone. He says the other side has absolutely no proof whatsoever anything bad even happened. So he's just asking for it all to be over. So that's where we're at right now. The judge is looking at just a little bit of evidence to see if the case should go to trial or if they get a summary judgment. That's the two crossroads at the end of this hearing. Here we go.
Start this matter.
And when you say start this matter, are we getting all the way through, or are we pausing when the attorney
Yeah, he just talks whenever he feels like it.
gets to the courtroom?
We'll see how it goes.
Okay. Okay. Right.
Good answer.
So if we're ready,
Shut up.
I'm ready to.
All right, let me put the matter, the style of the case on the record. All right, this is the matter of Marcus Hawkins and Casey Hawkins versus PM Flint River, Jonesboro, and others. Case 2022 CV 00377. This is defendant's motion for summary judgment. Defense is being represented by Mr. Lawrence Ross, and the plaintiffs in this case are being represented by Mr. Thomas Sampson Jr. and Thomas Sampson Sr. Is the defense ready to proceed?
Your Honor. And just to clarify, we also have another attorney on this matter for defense. His name is Tom Sippel, Sippel, just for the sake of the record.
Okay. Is the plaintiffs ready?
Yes, Your Honor, we're ready, Your Honor.
Yeah, so I was wrong.
All right. You may proceed.
The defendant is asking for a summary judgment, not the plaintiff.
Mr. Ross.
Thank you, Your Honor. My name is Lawrence Ross, and I represent the defendants in this case. This is a case that arises out of an alleged trip and fall at the Flint River apartment homes. My clients are requesting summary judgment because the plaintiffs have offered no evidence in the course of discovery that my clients are liable to them. So just in short, Your Honor, I know you've gone through these motions, read everything, so I'll try not to belabor the point too much.
I have not, but
Okay. Well,
I would have loved to say that I have, but I have not. But I will. I always do that before I rule. So.
Okay. Well, still, I'll try not to repeat myself for your sake.
Okay.
So this involves, as Your Honor already spoke, Plaintiff Hawkins and his wife, Plaintiff Carrie Hawkins. I will refer to them as, if on a needy basis, as Mr. Hawkins or Mrs.
Casey,
Hawkins.
not Carrie.
So Mr. Hawkins is employed by the Clayton County Sheriff's Department. And on this day, June 23rd, 2020, the date of the subject incident, Plaintiffs were called to assist in responding to a vehicle stop. That vehicle stop led to a smell of marijuana, which also led the officer and his other officer that was there as well to ask about where they purchased the marijuana. And
Snitches
after
get
gathering
stitches.
some information, the occupants in the vehicle identified the subject apartment unit in Building I as the place where the drugs were allegedly bought. So after gathering the information from this vehicle, Mr. Hawkins proceeded to the identified unit in Building I. Mr. Hawkins, accompanied by Lieutenant Bradford, knocked on the door, spoke to the individual that responded to the door. They smelled marijuana and asked all the occupants to step outside. After detaining all of the occupants, due to they were detained due to the amount of individuals in the unit, so for their own safety. So they proceeded to detain them, question them, and a short while after, one of the individuals that was detained, I believe his name was Slade, as it's used in this proceeding, somehow got out of his cuffs and proceeded to flee from custody. Mr. Hawkins, as a result, pursued this individual down the stairs of Building I. In pursuit, he saw this individual, Slade, trip and fall down the stairs. And following that, Mr. Hawkins also tripped and fell down the subject stairs. We are here for today. So as a result, in short, that matter is what brings us to this lawsuit before you today, Your Honor. Now, to get into the argument, Your Honor, in order to prevail on summary judgment, the moving party must demonstrate that there are no genuine issues of the material facts and that the undisputed facts viewed in the light most favorable to the non-moving party support judgment as a matter of law. So the first question we have before us today is what was the duty that was owed to Mr. Hawkins? And Georgia courts have considered.
That is not my first question, guys. My first question was, did he get caught? Did the guy running away get caught? Did he get injured too? What happened to him? Slade. I looked. I looked through all court dockets for Slade in Georgia. I paid for an account so that I could get the results of this and I could find the Slade person to see what happened. And then I couldn't find it. I couldn't find it anywhere. But that's all right. Just ignore the most important part.
Consistently held that to state a cause of action of negligence, for negligence, it is necessary to establish the essential elements of duty, breach, proximate cause, and damages. There's no evidence defendants violated any duty owed to Mr. Hawkins to him because first, defendants had no intention to cause Mr. Hawkins any harm or injury, and plaintiffs have not presented evidence that they did. And I'm going to let plaintiffs argue what they want to argue. I don't want to get into that. But also, second, there's no evidence that plaintiffs can point to showing the level of recklessness or indifference to establish such misconduct on the part of the defendants. Your Honor, as part of, and you've seen in the, or what you will see in the exhibits to our motion, Exhibit B, Lyle Lanzel's affidavit. Mr. Lanzel, the president and CEO of PM Residential Management, testified that as part of the general duties and responsibilities of the employees on the property, they were to traverse and go around the property, looking at the staircases or whatever it might be, looking for potential issues or problems with the subject property. Also, you'll see, Your Honor, in our another exhibit, the lender correspondence from Wells Fargo. They conducted a thorough inspection of the property. And some of the things that the entity that they got to repair or to find that was wrong with the property was paint chipping and peeling to the stairs, anything wrong with the street or any of those matters.
He repeated himself a lot, a lot, a lot. So the what he's saying is that they hired maintenance people to check their buildings. They have maintenance people and they check their buildings. So there can't be a problem. And then the lender, Wells Fargo, also came out and checked their buildings. And Wells Fargo gave them a list of things that need to be done. And it was just painting, paint chipping, and things like that. That's what he's saying. He's saying there can't be a problem with the steps because there's things in place to fix things like this.
And there was nothing within that had anything to do with building I. So just to summarize, the on-site employees routinely looked at the property to see what was wrong, what maintenance needs, what were the maintenance needs, and a third-party entity came on to also see what was wrong with the property, and neither the lender, neither the on-site properties, or even the residents that stayed there complained about the building I or the stairs
Everything he
based on
just
the
said is
evidence
a
that we
lie.
have.
Lie, lie, lie.
Because a defendant is entitled to summary judgment when it pierces the plaintiff's pleadings by showing that one of the essential elements is lacking. And here, it's clearly lacking. As I said, we're not disputing that Mr. Hawkins was injured. But what we are saying is that Mr. Hawkins does not know exactly how he fell. Based on the fact that, well, let me just back up a little bit. Plaintiff testified that he does not, that he knows what caused his injury. He says the only reason he fell was because of the subject staircase. And he said that if it was not for the subject staircase, he would not have fell. However, when asked if he went to step, and Your Honor, if you want to look at the transcript while you're listening, page 38, line 18. When asked if he went to step or how this injury occurred, he stated, "I know I was running down the stairs. When I tripped, I know my knee hit the ground, but besides that, he could not testify to any knowledge as to what actually caused his fall."
He testified it was the
They
stairs.
obviously had procedures to look for defects, but unfortunately, it wasn't found. Because it wasn't found is an evidence that they did not have the ordinary standard of care when looking after the premises. And without that, there's no willful or wanton misconduct, and they cannot be liable to the plaintiff for this injury. And for those reasons, Your Honor, we just do not believe that there's evidence and summary judgment should be granted in this case.
Is the defense ready to proceed? Yeah, I'm sorry, the plaintiff. It's the plaintiff.
Yes, ma'am. Thank you. Thank you so much.
I love this guy.
Your Honor, let me kind of begin. I noted initially you said that you had not, I guess, read the brief. So if I may, if you'll indulge me, I'd like to start with some of the exhibits and the pictures to just kind of paint the picture of what it is that we're talking about. And the first exhibit that I'm going to show you is really the actual stairs where Mr. Hawkins fell. And if my paralegal can pull up those pictures, I want to show those on the screen to you, since you may not have had an opportunity to look at the damaged stairs. All right, now these pictures, Your Honor, if I may, these are pictures of the stairs, and I'm going to have my paralegal kind of scroll down.
I am not going to lie to you. If I encountered that stair while I was trying to walk, I would fall down. Just looking at it while I'm walking down would make me fall down. If I was trying to run from the police and I encountered this stair, I would definitely break my neck. Yep, my foot would not be able to understand what to do in this situation. It doesn't look bad, But I'm telling you now, that would take me out. It took both of them out. And I'm wondering, like, so the first guy fell, the guy watched him fall, so he's running and then he falls. Did he like he says his knee hit the ground, so where did the other guy go? Did he like land to the right or to the left? Did he miss him? Did they land right on top of him? They catch him that way? I mean, think about it. He took one for the team and caught the bad guy that way. Maybe. I don't know. All I know is if I encountered this step, I would yell for my kids, "Grab mom's hand. Come on, help me down." Maybe. Maybe. They wouldn't, but maybe.
We're going to scroll down from through all of these particular pictures. These pictures have been attached. They're in evidence. They're part of the depositions in the case. They have been identified by Mr. Hawkins, the plaintiff, as the stairs in which he fell on the day in question. They've been identified also by Sergeant Bradford. Sergeant Bradford was an individual who actually worked for the Flint River Apartments as extra security during that time frame, and was with Mr. Hawkins during the time frame that he fell. All right. And as you can see from these photos, these are severely damaged, dilapidated, deteriorated stairs. Plaintiff has identified an expert witness, a Mr. Cody Pless, who's an architecture expert who designs, builds, and maintains these types of stairwells, if you will. And he's opined with an affidavit that's in evidence that this is the type of damage which does not occur overnight. This kind of damage occurs over time, and his affidavit is attached as kind of an exhibit to plaintiff's response to the motion. And I believe it's exhibit exhibit M
I
in
think
the
I'd be
plaintiff's
fine going
motion.
up. It's just going
In
down.
addition to problems with the stairwell, what you'll see kind of to the left, if you will, you'll see a railing. That's called a guardrail.
That's called
The
a
stairs were also
guardrail.
supposed to have what's called a handrail, which the stairwell didn't have in violation of code. And it was this hidden danger which caused Mr. Hawkins to fall on the day in question and injure himself. All right. One of the things that I want to point out, and I heard defense counsel note that there is absolutely no evidence in the record to point to a genuine issue of material fact. I believe that's just a gross mischaracterization. This evidence here, notwithstanding the testimony that this type of damage would occur over time, over an extended period of time, it's self-evident from the pictures that this didn't happen overnight and wasn't some simple, minor, acute problem that occurred. And so there's a genuine issue of material fact. Yeah, there are employees that have testified that they examined the problem or examined the area and never saw a problem. But there also is evidence that this was a long-standing problem. Their own employee, Patrick Eason, who was a former maintenance man, as well as Sergeant Bradford, who was their security officer, described this place, and excuse my French, as a veritable shithole. Dilapidated, rundown, not taken care of, and dangerous for people to live at. And so that's the testimony that we have in the record with respect to that. They were put on notice, and I'm going to take these pictures down and show you something else, which is a statement and a notice from the mortgage company Wells Fargo. And this particular notice was, which is attached as Exhibit C to our response, was given to Flint River over 1 month, almost 60 days. I think this was May 4th. The incident happened on June 23rd, where Mr. Hawkins fell. Okay. And what you'll notice if you go down, they tell, and if you look under the part where it says the inspection revealed the following items of deferred maintenance. And this is the second notice that they have gotten with respect to these issues. And it says peeling chipped steel breezeway staircases affect about 25% of garden apartment buildings. And if we go down into this exhibit, we'll actually see an example of some of the stairs that they're talking about. And go down, keep going. And if you notice to the right, this is the back of the stairs, or the bottom, and what you see plainly in this picture.
See, that would take me out. I'm telling you, if I would try to put my foot on that, I would get confused. I would have depth perception issues, and that would be it. I would be gone.
Picture is dilapidated and warped metal. That's part of the problem. That's a consistent and hazardous condition that's noted in 25% of the staircases throughout the complex. No notice was ever, no inspection was ever done as a result of that. They don't have any evidence of doing an inspection. They don't have any evidence of actually repairing the stairwell in which Mr. Hawkins fell. Now, a jury can determine that that is egregious, that that's intentional conduct, that that is basically putting a Band-Aid on the situation. And that's especially true in light of Patrick Eason's, some of his testimony, which I quoted. If you look at page 3 of our brief, and in his deposition on page 21, on page 3 of the brief, I talk about that. He says, I'm going to tell you the truth. It was unlivable. He said the standard did not even meet the standard of a D-grade property and was in a severely deteriorated condition. I asked him the question in his deposition. And he says, it was really that kind of way. It wasn't what you call an A, B, or C property, not even a D. They ain't really a D or F. It was bad, man. It was bad. And I asked him, I said, a deponent has described it, and forgive my French, he says, okay, as a shithole. That is exact. I didn't want to say it, but that's what I would refer to. And really what the court said in analyzing that case is, if you are aware, and the folks in that case were aware that these people who were licensees would be on the property that day, if you're aware, and this is the key word, should be aware that licensees will be on your property frequently, then you need to take reasonable steps. It's willful and wanton to allow them to be exposed to a dangerous condition, okay? In this case, their employee, Mr. Sergeant Bradford, who testified that this place was a shithole, also testified that the police were there every day due to the crime that occurred on the property.
Are there every day.
And I think this is important for the court to really take a look at it, because their brief is really a gross, they cherry pick bits and pieces and ignore the testimony where he clearly talks about how he failed. And Miss Meadows was questioning him during this time frame. And it says, and this may sound like a stupid question, but I'm kind of a clumsy person, so I'll kind of fall on my own from time to time. What caused you to trip and fall? Answer, the stairs.
The
There was a
stairs.
broken stair. What do you mean broken? Like the cement on the stairs, like the edge of it. You could put your hand through it. It was like broken. So I understand
For those of us up north, it's cement. The cement was broken.
these are
You're welcome.
concrete stairs. Yes, ma'am. Maybe framed in metal, but there is concrete on top. Yes, ma'am. Question. And you said there was a piece of concrete that it was fully gone. It was missing in the crack of the stairs or the metal piece in the stairs. The little part is missing. So again, the characterization that there's no evidence, there is a plethora of evidence. There
Plethora.
is a mountain of evidence.
Great, thank you. No questions. Mr. Ross, can you give me a 5-minute reply?
No,
Or
he cannot.
otherwise I'm gonna have to step out and come back.
Yes, Your Honor, I just wanted to acknowledge a few quick points that opposing counsel brought up. Opposing counsel seems to rely a good bit on Mr. Eason's testimony, former employee. As he said earlier on in his argument that Mr. Eason spoke with the managers and the employers that worked at the property regarding Building I and how a work order was put in for these stairs and how, you know, the complaints of these Building I stairs were Your Honor, there's no work orders. And you can look at the affidavit that we spoke of Lansdale. There was no evidence of any work orders for Building I that had to do with the stairs or anything. As you can see from the Wells Fargo third-party report, that it did all the issues and problems that they found with the properties while there are shared issues with them, and you see the pictures that they took. It has to do with unrelated buildings, and Plaintiffs' Counsel seems to want to apply the knowledge that they gained from these reports from this third party and insinuate that they also had knowledge for Building I as well. There's no evidence of any tenants or employees or third parties that have to do anything with Building I. Hawkins states, or Miss Meadows states, okay, I guess I'm just confused then. This area of the stairs could cause you to fall. If you may describe it to me, but do you know, like, did your foot just kind of went up a step there? Was nothing there and it fell forward, or did your toe get caught in it? Mr. Hawkins states, I know I was running down the stairs when I tripped. I know my knee hit the ground. Says nothing of how the stairs caused it. All he said was he just knows he was running and my knee hit the ground.
I'll read the whole deposition.
I'm done.
I'll read the whole deposition.
In other words, stop
Oh.
asking.
Page 39 when you get a chance, line 4. But it's clear that Mr. Hawkins doesn't actually know what caused it. He's just, well, I fell, my knee hit the ground, so it must have been the stairs. And that's not enough to prove causation for how, whether it be stair 1, they were talking about stair 1, stair 2, stair 3, whatever it may be. He's not sure of what actually caused him to fall. So and I don't want to keep you here all day, but also the Cooper case, going back to wanton or willful misconduct, again, you know, there's case law revolving around what police officers are considered when entering the premises. It's not a limit to how many times they've entered the premises. They're a licensee that comes on for an emergency. And this case, while it does involve premises liability, does not cover anything that has to do with law enforcement and how Georgia law sees them, no matter how many times they frequent the property or how infrequent their attendance may be. But besides that, unless you have any other questions, I'll rest.
All right.
Whew.
Thank you all. I am a little behind on some of my orders. I'll be candid with you. I'm working on a case now. I have to crank out about 4 more orders the supremacist liability matter that's on the trial calendar next month. So that is given my primary attention, but I will review all of your motions, exhibits, responses, and get you in order as soon as I can.
Thank you,
Your Honor.
I appreciate you today.
All right, thank you for your patience as well. And you all are free to go.
So that all happened a while ago. I waited until she rolled before I put this out so that you had an answer. The trial is going on. He did it was not thrown out. He lost, saying that they presented no evidence. They did. They presented hard, cold evidence that the stairs caused an injury to that officer. Um, but it didn't really say. Now, this was a couple years ago, and it sounds like the officer is still on light duty. So I don't know. I don't know what's going on with his leg. We'll never know. I mean, we'll never know unless I don't know. Unless at court, if we happen to see this trial, um, they say, well, he's back to work now, but he lost 4 years of service. I think it happened in 2020. I'm not sure. It could have been 2021, 2022. It was not 2023. So I know it was a couple years ago. But they're backed up in Atlanta. Atlanta is really hard with the law, criminal and civil. They're just overwhelmed with cases, as you see, just in Judge Manning's court. Just, I don't know what they need to do something to fix it because people are just sitting in jail forever, just waiting to be indicted. But yeah, they'll figure it out. They'll figure it out. But that's what I got for today. Just an interesting video. Remember, if you want to see the entire video, which again, don't yell at me if you get a little bored and fall asleep in the middle of it. It's on my Patreon. My Patreon is Court Vibes, of course. And you don't have to pay to watch the videos. All the videos I put there. I have the Australian judge lawyer who is amazing, the greatest I've ever seen. I have Judge Fleischer on there. I have other full trials on there where I only cut clips of it for my stream and for my videos. You can find them there as well. Okay, that's all I have for you today. I'll see you in my next stream, guys. Bye.